Hi, this is Mike Delsignore. In today's video, I'm going to talk about will bail be required in a domestic assault and battery. So I handle domestic assault and batteries all over Massachusetts, and I've been in courts throughout Massachusetts, and I'll give you a general breakdown of whether you're going to be required to post bail in a domestic case. So first type of case is you have no record. You get into an argument with your wife or your spouse, maybe even alcohol is involved, and the police come, you both regret calling the police. Your wife, your girlfriend says something to the police and they arrest you, but later she doesn't want to pursue the charges. It's a common situation I face all the time. I get calls on that almost on a weekly basis. So in a case like that, when you have no record, there's no significant injuries, you're going to be released on your promise to appear in court. It's called personal recognizance. You'll have to appear at a future court date. If your spouse or your girlfriend doesn't seek a restraining order, they'll probably release you on a condition that you don't abuse the victim, so that nothing further happens. So that's the case, the type of case with no record. Bail's unlikely to be imposed. If you have a little bit of a record still, but didn't default on your prior cases, there still probably wouldn't be any bail. The purpose of bail is to make sure you appear in court. So it's not supposed to be to punish you before a case is resolved. It's not supposed to be a punishment, but it can be used that way. But if you have no record, most judges won't require bail. Let's say a judge does want a cash bail that you can't post. There's a right to a bail appeal in Superior Court. So you have a right to have another judge look at the bail and determine if that amounts too high. Many bail appeals are successful. I've done quite a few bail appeals in my career, and they can often be successful. Let's say you have a record, and it's not just a domestic assault and battery charge, but also strangulation. In that type of case, while it's likely you might have to post some cash bail if you have a little bit of a record, the bail would probably be between the $500 and $1,000 mark. If you've been done jail time, or if you've been through the system before and you don't appear in court, the bail can even be higher. But one of the things to be concerned about is when there's a strangulation charge, the government can try to hold you without bail. It's called a 58A hearing, a dangerousness hearing. And at that hearing, they're going to prove that no conditions of release can assure the safety of the public. So when you're charged with domestic assault and battery and it's accompanied by a strangulation charge, it's really important for you to go to court with an attorney, because you might not be leaving the court. They may take you into custody and you could be held for 2-3 days. And while sometimes your attorney can't prevent that from happening, at least your attorney can get a shorter date, maybe get the discovery, start getting the case moving, so you're not in limbo waiting for this dangerousness hearing. Now, it's a high standard to hold somebody without bail under the dangerousness statute. They're going to prove that no condition of release can assure the safety of the public. Now, often I can convince a judge that there are conditions that the judge should impose, such as GPS monitoring, no contact orders, and things of that nature. Often alcohol treatment might be involved if there's an issue of alcohol, or some type of counseling. So keep in mind, if you have no record, you're unlikely to have to post cash bail. If you have a record, or if it's strangulation or felony charges, not just strangulation, it could be assault and battery on a pregnant woman, assault and battery with a dangerous weapon, you could face a dangerousness hearing. So those are the issues you need to be aware of on your first court date. What's going to happen after? The case will get a pretrial date, and often the best strategy is to try to get these cases set down quickly for trial, because often the alleged victim is not on board with the case. There's ways the government can prove the case without them, such as by relying on 911 calls or independent witnesses or your statements. But the first court date, what we want to do is we want to get the report, we want to get you out of court and get you released. That's the goal. Get the report, find out where this case is going. We'll formulate a strategy. We'll do whatever we need to do in order to move the case as quickly as possible through the court system. We may have to wait for the 911 call or for the government to produce other evidence. And once we get that 911 tape, then we can decide, is this a case they can prove, or will we have to do some legal motions to have the court exclude that 911 call from evidence? So a 911 call doesn't automatically come into evidence. It's hearsay. In other words, under the law, I can't say Joe said something and that's how I know something. So as in a domestic case, the way that would play out, the police report will read, the victim said her husband punched her. Or in a 911 call, the victim will say, my husband hit me. So that call can't be played in court under the hearsay rule. It's an out-of-court statement used to prove the truth of the matter asserted. So that's the standard definition of hearsay. There's a lot of exceptions. It's what every law student learns, that hearsay is an out-of-court statement used to prove the truth of the matter. You need the person who witnessed it, who has firsthand knowledge, to come into court and testify. In domestic cases, when the victim doesn't wish to testify, they try to use that statement. They say, well, it might be hearsay, but it's an excited utterance. And there's some case law that goes both ways. Sometimes the evidence comes in, sometimes it doesn't. You need a lawyer that understands the law of the Sixth Amendment and will make an objection. I've written on this issue many times. I've written blogs. I wrote an article for Lawyers Weekly. I even had a seminar where I had judges on the panel and we had a whole discussion for other attorneys. So that's one of the issues you need to be on the lookout for in a domestic assault and battery. My name's Michael Delsignore. If you have questions about bail in a domestic assault and battery, if you have questions about how these cases are handled in any particular court anywhere throughout Massachusetts, feel free to contact me. I'll be glad to help you. My passion is to help people get their lives back together after a criminal charge. Call me at 781-686-5924.